Good evening, ladies and gentlemen. You are now tuned in to Fair Housing. It's the law. Today, I got my friend Rick Martinez joining me, and we're going to give you all today 3 scenarios that could happen to you during the renting process. Stay tuned.
I hope one of them is not about my looks.
You ready?
Yeah, okay. Now, I'm going to do a scenario for him, and I'll be the guy trying to, see if he qualifies.
He'll be the landlord.
The landlord.
I'm the tenant.
And you don't want to hear
Let's do it.
like this, but let me give you an example. So,
Action.
Here we go. So you're applying for an apartment here. How many kids do you have?
I have 6 kids.
Okay.
Is that okay?
That's good to know.
So that's one scenario. Has that ever happened to you? Now we're going to give you another scenario.
Okay. Do you have a job?
No, I received disability. Is that okay?
Well, soon enough find out.
So that's the second scenario. Has that ever happened to you or anybody you know? Now we're going to give you a third scenario. This time, I'll be the landlord.
Okay.
You be the renter. How you doing? I've been looking over your application here. I think we're going to have to do a criminal background check. Is that okay?
Oh, I didn't know you had to do that.
Yes, we check your criminal background.
Is that standard for everyone? Okay.
Has that ever happened to you? That's 3 scenarios that could happen. Real scenarios in life, people. Now, I'm going to bring in Miss MJ Borelli to break it down to y'all and tell you what's factual and what's not.
Okay.
Thank you.
You got it, bud.
Okay, well, welcome to Fair Housing, It's the Law. And those were just a couple of little events that happen to folks a lot of times when they're a home seeker. They're learning to, or they're trying to rent a place to live.
What you think about our acting?
Your acting was very realistic, I must say. And I think what we looked at here was, in the first scenario, the landlord and the would-be home seeker, Mike here, the eyebrows were raised at the number of kids that Mike said that he had on his application. And what that is about, or what that could be about, I mean, there's not a lot of information there. It may have meant nothing. But there is a prohibition under federal fair housing law against discriminating against families with children. And really, this is about families that have minor children in the household, whether they're related to them or not. So that could be your foster kid, or you've got partial custody and you have the kid with you 50% of the time, for example, or you're watching somebody else's minor child during the day as they work. So, it's not against the law for the landlord to raise their eyebrows over the number of kids that Mike had on his application for this 2-bedroom apartment, presumably. But it is it's a flag. What's going to happen? Am I going to get different treatment, or am I not going to get this rental because I have kids? And these are really common complaints that we hear when people call us with the complaints at the Fair Housing Council.
Yes. We also
Go ahead.
want to discuss the next one?
The next one was about disability and source of income.
Do you have a job is what the landlord asked me.
Now, in and of itself, it's not against the law for the landlord to ask you if you have a job. It would be against the law under state fair housing laws in California to not rent to him if he didn't have a traditional paycheck. In this case, Mike had Social Security, disability, pretty common income for folks who are disabled, and landlords have to rent to you, regardless of your source of income, if you can show the ability to pay. And that's probably one of the bigger issues here. If a landlord refuses to rent to you, and there's plenty enough income in the household when you combine everybody's income to rent the apartment or house, then it would be a violation of state fair housing rules to not rent to somebody because they had a government income or a fixed income.
Okay, say they might accept disability. Would is that matrimony when you've been married and you received like other ways, say child support?
Child support?
Would
Oh,
those
it's same
funds
thing.
be the same thing?
If that's part of your income to have child support,
Alimony, any of that
yes,
falls.
alimony,
that's
child
your
support,
income.
as long
it's
as
your
you have the
income.
ability to pay the rent that's being offered, and then the landlord refuses to rent to you, then they would be in violation of state law.
Okay, we covered that scenario. I'm pretty sure a lot of people out there
Now,
have ran into that.
oh yeah, it's pretty common because we hear about it all the time. Now, the third scenario could be tricksy. I'm not sure if there's really any discrimination going on there, but one of the things that I have noted over the years with complainants who believe that a landlord didn't rent to them because of some sort of discrimination. This especially happens with black people and other people of color, where often, when you ask the landlord or the property manager what you have to do in order to rent the place, and generally it's fill out an application. And it's pretty common these days that the landlord does a credit check to make sure that you have the ability to pay again. Criminal background checks, they're legal. They're not a violation of federal law. They're not a violation of state law. It's how you use them. And if you were, only, and this has happened in a number of cases we've looked at over the years, if you were only telling the applicants who were people of color, black people, brown people, whatever, that they were going to have to undergo a background check, but you didn't offer that information to, say, a white applicant, you probably have violated the Fair Housing Act. If you refuse to rent to the person, you're certainly offering different terms, rules, and conditions of tenancy as a landlord if you're doing that to one person and not the other. There would be nothing wrong with telling all applicants you have to make an application, you have to undergo a credit check, and we also do a criminal history check on folks. Now, if they're going to use those protocols for every single applicant, they've done nothing wrong.
Okay, I was going to ask that, like, criminal background checks would be sufficient as long as they was doing it all across the board.
Yeah, you got to do it with everybody. It's if you make a rule, if you have an apartment community and you're a manager, a property management company, everybody has to be treated equally. So whatever amenities you're offering have to be offered to all. Whatever rules you're making, community rules that you're making, it has to be inclusive of all your tenants and or applicants. So it's kind of like offering different rules for different people because of either race, color, national origin, religion, gender, disability, family status. That's about those folks that have the young kids in the household. So we used to see commonly in all kinds of rentals throughout California, other places too, where people who had children, people who had minor children in the household, they may be rented to, but they would situate all the families with children maybe to the back of the complex and not offer the same amenities maybe In this case, housing choice. Well, I really wanted to have something up front, upstairs. No, all families with children have to go here. So if a landlord has that kind of a policy or a rule going on, they're in violation of the Fair Housing Act.
What about applications that ask your race? Do we still have to put our race down?
If there are landlords out there and that are asking a person for their race, they would actually be subject to prosecution under the Fair Housing Act. So, that used to be really common. Now, I have run into, in the course of investigations, where landlords coded applications in one way or another. I had a case back in 2014 where a landlord did that. And when we, demanded and subpoenaed all their rental history records in the course of suing these people in federal district court, we determined that they had coded applications for folks who were black, and they had a different code for folks who were Hispanic, and they also had codes for families with children. And of course, they were discriminating against these folks by not offering to rent to them in some properties. So yeah, this goes on even today.
Far as eviction notices, is it a time expiration date on eviction notices, or can eviction notices, not eviction notice, but evictions on your
Record?
record?
Oh, yeah. They're there forever.
How long is that there?
Forever.
Forever.
Ever. Remember, we live in a digital age. Anything is searchable on the internet, and anything and everything is on the internet somewhere. So no, they don't ever. It's not like a bankruptcy. Okay, if I wait so many years, it's not going to nudge against my credit anymore. It's not going to be on my record. These things are always there. And there's searchable court records, all kinds of things that landlords often engage companies that do nothing but search those kinds of documents, like UD registries for evictions. So, it's always going to be there.
So even if you're 21 and it happened when you was 21, you're 47 now, it can still be held against you legally.
Well, it's not held against you legally. Are you talking about as a reason to not rent to you? Because it's perfectly legal for a landlord not to rent to somebody if they do have evictions on their record.
Right.
There's no prohibition against that. Keep in mind, sometimes landlords, property managers might use some of these things as an excuse, when really what they're looking at is a person's race or gender or national origin a lot of times. But, and if you're watching this and you think that landlords don't want to rent to you because you're a person of color or you came from a different country, you certainly can call our offices, and we will investigate that claim to see if that's really the reason. But landlords don't have to rent to you if you have an eviction on your record. Landlords don't have to rent to you if you have a bad rental history, i.e., moved out in the middle of the night without paying rent, for example, or left damages in the rented unit that you're vacating, and where the landlord is looking for you for damage costs. So if those kind of things are popping up on your rental history, landlords can use that against you. Remember, the only thing that they can't do would be, I'm not going to rent to you because of race, color, national origin, religion, gender, disability, family status. If they're refusing to rent to you because of those reasons, they're in violation of the law.
Oh, okay. What about, MJ? Can the landlord raise one tenant's rent without raising everybody's rent, even though I might stay in a 2-bedroom and this another 2-bedroom, but my rent got raised.
Well, as long as the landlord, because they may have different rules, or not different rules, but different ways they may have negotiated the rent, as long as they're not raising it because of the person's race, color, national origin, etc., there's no problem with that. Landlords do that all the time.
Oh, okay.
It's not expressly illegal. So,
That's a lot. We covered a few things there. I wish we had a studio audience to respond, give us some more things y'all might want to know. We're going to have that coming in the future.
well, I think there's comments with some of these things that go to YouTube, for example. So,
Yeah.
if you have a comment, but even better, you need to probably call our offices in Fresno at 559-244-2950. And I think we have that number up on the screen as well. So
Yes.
if you believe you're a victim of housing discrimination for any of these reasons, I don't know how much more time we have for this segment, but
14.
about 14? Okay. I think it's interesting to talk about how to keep your tenancy once you do get a rental.
Yes.
And what often happens is, you get the rental, you've gone through all of this protocol, you've filled out applications, people have done your credit check and all this, that, and the other. And then you might do something that causes the landlord, to be upset with you and tell you you've breached some part of your rental agreement. And you can breach a rental agreement even if you don't have a written one. I mean, if it's your understanding with the landlord that you need to pay the rent every month, and it's due on the 1st, and you don't do that, you don't pay that rent, then you're in breach of that contract or agreement that you've made with the leasing party, the landlord or the property agent. And what can they do if you don't pay your rent? Well, they can get you out of there pretty jiffy quick through a process in the courts called an unlawful detainer, which is basically a lawsuit that the landlord or owner wages against you as a tenant for not paying the rent. It's a breach of agreement. It's a regular lawsuit, and you're gonna, if that happens to you, and you receive one of these court papers called an unlawful detainer, it's going to have a summons to the court attached to it, then you need to file an answer to that complaint that the landlord has lodged in the court. And actually, when you receive one of these unlawful detainers, it'll refer to that answer. But it's up to you to go to the courthouse and file your answer to this lawsuit, and the answer is going to be something like, why I think I don't need to pay the rent. And you always need to pay the rent. Very few cases where you don't pay the rent. And those situations have real extenuating circumstances. For example, your water heater has been out for months and the landlord refuses to fix it, and therefore you don't have any hot water to bathe or do dishes or whatever. Notwithstanding the fact that state and local laws would prohibit a landlord for renting a place that didn't have something like hot water. There's other things. They have to have heat. Hot water is a major deal that illustrates whether or not the unit that you're renting is habitable for human beings. Okay, so this guy hasn't fixed your water heater for 3 months. Looks like you need a new one. And you actually can withhold rent for repairs. I mean, this is allowable under state law. Don't necessarily advise it unless you've got somebody to help you through this, like your local legal aid group, for example. Because you would have to serve some kind of written notice to the landlord or the leasing party of your intention to withhold rent until this specific repair is being made. You can't do this for a leaky faucet. And you can't do this for, these minor kinds of things. But, something like your water heater for hot water, that's a habitability issue. Landlords are supposed to do it under state law. So you can serve them notice, this is my intent, I'm not going to pay you until you make this repair. And once you make this repair, I'm going to give you all the rent I owe you.
But don't go partying.
No.
You got to hold on to the money because rent has to be paid.
Technically, you should put it somewhere in an escrow account for the period of time. But can a landlord go ahead and, while you're trying to do this, file an unlawful detainer against you for non-payment of rent in the courts? They do it all the time, so you have to be really careful. It's much better if you're doing this with supervision, once again, to use your local legal aid group or an attorney would be your best bet. People get evicted all the time, and they just wanted to get their water heater fixed or their heater fixed or some other major kind of thing. Now, true enough, if the guy does try to evict you and you actually wind up getting a hearing in court before the judge, I mean, certainly that's your affirmative defense, and you let him know that, I've got all this rent here that I've been withholding to pay them. I just want my water heater fixed. And, you might get the judges and the court's attention there. Don't bet on it. Unless you really have some good legal supervision to help you through withholding rent for repair, which you're allowed to do in California at least once per year. Hopefully you don't have a landlord where you have to do that all the time. But it's always better, in my view, to pay in protest.
Yes.
And then try to seek those same legal aid folks to help you get the water heater fixed. Or local code enforcement for your city or county. They could possibly also serve notice on the owner and demand that they make a repair that would be a habitability issue.
You don't want to do anything to threaten you having shelter. You need somewhere to stay. So you have to be you got to cross your T's and dot your I's and remember that it's business.
That's right.
The landlord is a business, so keep it business and communication. Make sure you're communicating. Don't let the lines of communication go down. Communicate with them. They'll most likely communicate back. Keep the communications open with
Very
everyone that's
important.
involved.
That's right. It's also a good idea if you could always get these kinds of things in writing, promises, etc. Because I have heard dozens of people in my time of dealing with folks who have housing issues that, that landlord doesn't care if I pay late or, if I miss this month, they understand. They know I'll make it up. This is why people get evicted, and this is why the eviction courts are, pretty much capacity right now, any day of the week. So don't bank on that. Another time I see problems with non-payment of rent, and keep in mind, partial payment of rent is still considered non-payment of rent. The landlord can use that against you.
Oh, that's a good one.
So you decide, well, I owe $450, but gosh, I'm $50 short, so I'll just give them the $400. Unless you've got some sort of an understanding in writing with this landlord or manager, that's probably not going to fly. You're going to be a really lucky individual if it does. And as Mike says, you don't want to put that roof over your head. You don't want to make trouble for that.
Don't jeopardize that.
This is the one thing that you absolutely priority one that you need. And that is to have a roof over your head. And if you've got kids, absolutely, this is the number one priority, that you got a roof over their head. And then you can fill in the blanks with all those other hierarchy of needs, like, food and health and all this kind of food and health and all the other kinds of things that constitute, daily life. But don't put that in jeopardy, and we see it all the time. I talk to people. I think the pandemic was a bad moment for society in terms of responsibility in these areas of like a rental. I still talk to people, and it's 3 years, almost 4 years since the shutdown of California during this pandemic episode, where people haven't paid their rent and they believe that they can't get evicted. This is a myth. You certainly can get evicted, and any landlord that hasn't done it to you already is going to get around to that eventually, I can guarantee you.
So, I was wondering about that. Say we have a discrimination case, and it's very likely that the discrimination case is a good case that this has happened, but the person hasn't paid rent in 2 months. Does it blurry the situation?
It could be a problem. Certainly the other side is going to argue against the discrimination claim, saying, hey, the landlord wanted you to leave because you simply didn't pay the rent. Yeah, it could be a problem. But we may be looking at other kinds of evidence that shows that the landlord did, in fact, discriminate. But yeah, it does blur it. I don't like cases that have a pending eviction for that reason.
That's a good one there. Rick, you got any studio questions for us? Anything you're thinking? Housing questions for the people.
Yeah, no, off the top of my head, no, not at the moment, sorry.
Well, I think everybody wants to know, can landlords keep increasing the rent, as we're seeing it all the time? And yeah, they can. Yes, there are state laws called the Tenant Protection Act in California that cap a percentage of the rents for some landlords and complexes. But as we discussed in the last video, it's really complicated. There's a lot of exemptions to landlords. We don't have, for the most part, in every place in California, and certainly not here in the Central Valley where we are, rent control. There is no across-the-board rent control. That's in some special areas throughout California, and it doesn't work. It's actually kind of a complicated process, having rent boards and rent control boards and that sort of thing. And whether or not, landlords have to petition when they want to raise rent, it's complicated. We don't have that here. And even if you believe that your landlord is not exempt from raising your rent yet again this year, the enforcement of the Tenant Protection Act is a dicey one, because it's going to entail you finding your own lawyer and having to pay the fees that the lawyer is going to demand in order to try your case. So the fact of the matter is, the way to get some of these rules changed is, tenants need to come together, they need to be political, they need to contact their elected officials and talk about high and unaffordable rents. And this is how you get rent control in your area. There was an attempt to do this statewide a few elections ago. There was a really, really bad voter turnout. So it really pays to pay attention to what the laws are, and it also pays to pay attention to what your rights are, and always read the statute, as we say. Read the law itself. It's all available on the internet. Thanks again.
This is the Fair Housing Council of Central Valley. I'm Michael Smith.
I'm MJ.
And fair housing is the law.
It is the law. See you next time.